Welcome to Just Theory. In this episode, we are speaking with Michelle Dempsey, professor of law at Villanova University, where she explores criminal law, feminist legal theory, and philosophy of law. We talk about working with John Gardner, finding a life in academia as a litigator, and the notion of robust consent. Please enjoy. Wonderful. Michelle, delighted to have you here. Welcome, welcome.
Thanks for having me.
Of course, we're very glad that you could make it. So as we begin every episode, same question. What made you choose a career in academia and why did you stay?
So I sort of fell into my career in academia. You would never guess, knowing me as a student in my younger days, that I was going to wind up an academic. So I studied philosophy in undergrad and then went to law school, and I knew that I wanted to go to law school. And I knew I was interested in philosophy, but I never thought I'd sort of become a philosopher. So I thought, law school and then something after that. And after law school, I became a criminal prosecutor for 3 years, and then I was a civil litigator doing plaintiff side personal injury work, medical malpractice, and some other sorts of cases. And through that experience, thankfully, I was able to get my loans paid off, not from the prosecutor salary, but from the civil litigation salary. And so my husband and I, we had my loans paid off, and we decided to move to England because that would be fun. And so I left my firm in Chicago and went to do what I thought was going to just be a 1-year LLM. And then I thought I'd probably go back to my firm and keep making money as a litigator in Chicago. And so during my LLM, I was at the London School of Economics and studying in criminal law philosophy. It was a terrific class. And one of the, maybe two of the pieces that we read in that class were written by this guy named John Gardner. And I didn't know who he was, and I didn't know anything about jurisprudence. I had some ideas of some thoughts, but I didn't know the people or sort of how the field worked. And so I read a couple of his pieces, and I was intrigued, right? I really appreciate coming across the work of people who help me understand things I want to understand better, right? I mean, I think that's maybe every academic discipline, but philosophers in particular, right? You sort of find pieces that you're like, oh, this makes a lot of sense. It helps me organize some thoughts, and it helps me see more clearly about 100 related things. And so it was a very, eye-opening and exciting experience to read John Gardner's work. And so I thought, well, maybe I'll go on and stay and do a doctorate. And so I asked to meet with him, and thankfully he was willing to take me on as a student. And so I went to Oxford to do my doctoral studies. Again, like not at all convinced that I was going to stay in this game, right? I sort of did it because it was fun and we were having a great time in England. I was fortunate enough to have my first child while I was studying for my doctorate at the beginning, and then I had my second child just before I submitted my thesis. And so it was just a great life, like I did not really expect to stay in it. I thought I'd go back and be a litigator. But fortunately, while I was studying in Oxford, I was asked to start teaching at Worcester, teaching jurisprudence and criminal law at Worcester and Brasenose colleges. And so I was doing that while finishing up the doctorate and having the baby. So I used to be very busy. And I just realized eventually that I really liked this. And I thought I could keep doing this, maybe, right? And it was going well teaching at Oxford. And so I thought, well, let's see if I can keep doing this. And so I just kind of fell into it, right? Like it was never sort of a plan. It was always sort of, well, I'll do this for a while and see how it goes. And oh, it's going well. So eventually we moved back to the United States. And I'm from the Chicago area originally, but we moved back to the States and wound up just outside of Philadelphia at Villanova University. And I've been very happy here, 16 years now at Villanova, and got tenure, got a chair. Like it just, in the back of my head, like I'm still fully prepared to go back and be a litigator if I need to, right? Like I keep up my law license. I teach evidence every year so that I'm sort of ready to go if I have to jump back into the courtroom. So yeah, it seems to be working out okay. So great, it was certainly never sort of a life's passion of mine or a life's goal of mine. I just sort of fell into it by accident.
I think most of our speakers share similar experience of kind of diving into practice, but then going back to academia. One question I'm really curious about your work with John Gardner. And could you share any anecdotes or stories, experiences? What was it like to work with him?
It was amazing. And for those listening who don't know, John Gardner very sadly passed in 2019, far too young. I believe he was the age that I am now. So he's no longer with us, but the time that I got to learn with him and be with him and become his friend and colleague was just, such a joy, one of the great joys of my life, really. I'm not going to get teary. You're getting teary. I'm not getting teary. So well, the first anecdote makes me look like a fool, but I'll tell it anyway. I reached out to John and emailed him and said, I've read these pieces of yours. And by that time I'd read a few others. And I said, I'm thinking about doing a doctorate. Would you be willing to supervise me? And so he said, well, I don't know, send me some writing samples and let me take a look at them. And he assigned sort of what he wanted me to write. And to his credit, which is very John, he wanted me to write critiques of his work. And so one in particular I remember was the wrongness of rape, which is a great piece he wrote with Stephen Shute. And so I sent him a pretty blistering critique of that. And I thought, well, let's find out who this guy is, right? Because if he is easily offended when people disagree with him, this is not someone I want supervising my doctorate. And of course, he was, absolutely delightful and delighted by the conversation that the critique gave rise to. And so we went back and forth on some of that. And then he said, okay, let's meet. So after I sort of passed that first bar, we met. And we met for coffee in London. So at the time, as I said, I was doing my LLM at the London School of Economics, and he was living in London. And so he thought, well, it's just easier to meet at a Costa Coffee in London. And so we did. And I said, now you're at Oxford, right? And he said, yeah, but I live in London. And I don't know if he was supposed to be doing that. I'm probably getting him in trouble. But I said, well, you used to be at King's College, isn't that right, in London? And he said, mm-hmm. And I said, so why would you leave King's then if you want to stay in London and this is where your life and where you want to live is located? Why would you take a job in Oxford? And he said, well, the job that I've been offered, or the job that I was offered at Oxford is not one that one refuses. So I think again, I had no idea what that meant at the time, right? He was just being modest, but I didn't realize he had, professor of jurisprudence and H.L.A. Hart and Ronald Dworkin, and now John Gardner, who was so young when he stepped into that chair. And so I just had no idea. I'd read some of Hart, I'd read some of Dworkin, but I didn't know. Anyway, so I did not.
This is honestly fascinating because Raquel Barat, as the Freitas has also said, who used to work with him too. I don't know if you're aware. She always shared just nothing but really warm anecdotes about John Gardner, and it just seems like it always warms my heart when somebody who is in a very powerful senior position has so much time for new doctoral students or just anybody who's intellectually curious and is just generally a kind person.
Yeah. And he was extremely kind and extremely brilliant, but he didn't pull punches at all with his doctoral students, right? So the second anecdote I have that I'll share about John is I'd started studying with him when I was quite heavily pregnant with my first child. And after giving birth and sort of getting back into the swing of writing, I spent like 3 months writing this chapter on criminal procedure. I was writing on the topic of prosecuting domestic violence. And so I thought it would be a good idea to sort of develop an account of how to think about criminal procedure more broadly and sort of develop my own model of it. And so I read everything there was on that topic. I wrote my chapter. I gave it to him. I was so proud of myself. And the meeting with him and with Carolyn Hoyle, who is my co-supervisor, went like this. So he said, "So I've read your chapter. It's very well researched and well written. I have no idea why someone pursuing the thesis that you're pursuing would need to include a chapter like this in their thesis. But it's great that it's done now. And so you can just take that and put it in your desk drawer and you'll have it for later." And I'm a fairly resilient person, I have to say. So I don't get knocked down very easily. But that was okay. So
a diplomatic way.
Right. Like, all right, well, I guess we're gonna start again. And so then I did start again, and it didn't take long after that before he banned me from going into the sociology library. And eventually he limited my reading to the jurisprudence section in the law library at the St. Cross building, and then the philosophy library on Logic Lane. Those were the only two places where I should be reading. And then I did that for a while, and then he said, stop reading altogether. I don't want you reading anything else. You've done enough thinking and reading, just write what you think. And so that was sort of the process that he used to kind of get me from those early stages of doctoral work where you come in and you're like, oh, I have to be an expert. That means I need to have read every single work on this topic. And, depending on how you understand your topic, you could die and still not have read everything that's been written on your topic. And so through that process of sort of narrowing the scope of my focus to scholarship that he was able to expertly guide me through, and that actually did speak to the things I was genuinely concerned about. Like, I really wasn't concerned about, I love criminologists, but I'm not a criminologist, right? I'm not a sociologist. And because so much had been written about prosecutors and criminal procedure in sociology and criminology, when I thought, like, what's been written out there, I was always, guiding myself toward these sources that weren't really what I wanted to do. And it didn't take long before I realized that there really wasn't philosophical work on the topic that I wanted to think and write about. And so he pushed me to just have the confidence to come up with my own ideas. So yeah, it was just such expert supervision. I think everyone who's worked with John has some similar kind of story.
And I guess the themes that you've been pursuing at the time during your doctorate with John Gardner are still present and very vivid in your present research. Your work on consent, your work on wrongs clearly overlaps with those themes pursued earlier on in your career. So I wondered if you could tell us more about your research interests and how they developed over time and how they mature in the two papers that you shared with us today on consent and on wrongs in the context of criminal law.
Yeah, thank you. Thanks. So to go back, some of my general interests come from my experience of having been a prosecutor. That's sort of how it started. I was taking an approach to prosecuting domestic violence cases that was quite controversial, I think rightly so, to go forward in cases even when the survivor/victim did not want the case to go forward. And I knew when doing that there were a lot of difficult issues around legal philosophy, political philosophy, moral philosophy that were floating around what I was doing that I did not have time to think about. So, my early doctoral work was just trying to sort of think through some of the choices that I made there, and not to justify them in the sense, I actually came out of that project thinking that, being less convinced that what I had done was right, than I was when I went in. So I wasn't trying to justify it. I was just trying to get more clear about the considerations that were in play, philosopher. And and as I've developed, I think you're right to notice that my concerns have sort of tracked a lot of the things that John was concerned about, particularly around wrongs, wrongdoing, justification, excuse.
Normativity, I guess.
Yeah, right. I mean, I say I occasionally have side quests into more general jurisprudence topics. So, the concept of law, authority, maybe normativity more generally. But I don't really consider myself, well, I mean, I kind of consider myself a general jurisprudent a little bit, right? But I do view those as kind of more side quests than the main thing that I do. Mainly, I'm concerned with questions of wrongdoing, justification, excuse, and so blameworthiness at the end of the day, and but then also how we respond to that, right? So I have done I'm also very concerned about the intersection of these questions as they relate to what is sometimes taken under the banner of violence against women or gender-based violence. I don't know that there's a perfect label to capture this, but things like domestic violence, intimate partner violence, sexual assault, sex trafficking. I've written on commercial sexual exploitation more broadly. I've written on these topics, and I don't always connect what I'm writing to those topics, but those topics are always sort of in the back of my mind or in view in the front, sort of not trying to defend any particular view as to what we should do about those things, although sometimes I have. But again, just to sort of try to think more clearly about the sorts of issues that they throw up. And so that said, with respect to the two pieces I sent you, one is consent in normative perspective. And it is an attempt to think about consent, which I understand to be something that plays a role sometimes in a justificatory way, but it sort of depends. This is the thesis I'm arguing in the paper. It sort of depends on which normative perspective you're adopting when you ask these questions. So should I, and I'll briefly introduce the other paper too. So there's that consent paper, which plays with some of those foundational issues of wrongdoing, the role that consent might have in either making something justified, it plays a justificatory role, or from a legal perspective, it plays actually an inculpatory role when there's not consent, at least when it comes to sexual offenses by and large. So that's that paper. And then the other paper I sent you is called Criminal Law's Responsibility, Responding to Wrongs. Or actually flip those two. I think it's Responding to Wrongs, Criminal Law's Responsibility. Yeah. So the idea there is the criminal law can and does play a role in responding to wrongs. And so that's the paper that kind of goes along with a line of work I've done thinking about how we as a society should respond to wrongs, right? When, if ever, should we be doing something about it, and what sorts of tools do we have available to us? That paper in particular is defending a couple points. One, it's that we have a duty to respond to wrongs, that the criminal law is one of the ways we can do that, that it's important that we fulfill that duty, at least with respect to some wrongs, right? Public wrongs, I'm not saying every single wrong anyone commits, we need to throw the criminal law at them. But criminal law is a tool we can use to respond to some wrongs. And just because we're using the criminal law to respond to wrongs doesn't necessarily mean we need to be punishing, right? I think it's helpful to draw a wedge between appropriate responses to wrongdoing, even serious wrongdoing, and when, if ever, is punishment justified. And so I draw on some of the work by Nikki Lacey and Hannah Picard, sort of playing with those ideas. And I draw on Leora Dan Katz's work on responding to wrongs. And then at the end, I sort of take up this idea that has been debated in the United States well, it's not as if it just started as a debate in the United States in recent years, but it certainly blew up in the United States in recent years, the idea of just abolishing the criminal law altogether. And I hope I take very seriously in that paper, because I do take very seriously the horrible injustice wrought by the criminal law, and that it may just be a tool that is so morally abhorrent that it cannot be put to any good use, right? Even if it could help us fulfill this duty that we have to respond to serious wrongdoing, we ought not to use it because it's so morally defective. We just have to start again. And so I take a look at some suggestions that have been made about how to start again, and how we might be able to start again while also fulfilling this duty to respond to wrongs, and to make one of my key points is that we have to make salient the wrong-making features of the wrong. So we can't just treat it as if we're responding to harms. We have to really focus on that which makes the conduct wrongful, and make sure that we're sort of making that salient and condemning that in our responses. And by the end, I have this kind of cheeky conclusion, which is, if we try to redo this and we're actually doing it in a way that fulfills our duty, we're basically going to wind up just creating a criminal legal system, right? Because we're going to want to have rules that are announced ahead of time. And we're going to want to have ways to change those rules when they're oppressed. So we're going to have to be able to posit rules. We're going to have to be able to change the rules. We're going to have to be able to adjudicate particular cases to decide whether this is a wrong and how we should respond to it. And so we are ultimately sort of going to wind up with a legal system in the end. And so I guess it's maybe not an attempt to say that the abolitionist project is doomed to failure, but that it's not so easy to just say, hey, let's abolish this system that we have, because it does leave us with this serious problem of how do we respond to wrongs that even abolitionists believe do need some kind of response.
I found both papers very much thought-provoking, both analytically, philosophically, but also socially. So it's quite interesting. I really admire how you skillfully write across those spheres, so to say, the conceptual, analytical, but also social, and you combine them beautifully in both papers. If we could dig into the papers for a little bit, with the first paper, I was fascinated with the conception of the robust consent that you touch upon in that paper. And my analytical brain and my analytical side was provoked by that concept, because it's a very conceptually rich account, the idea of robust consent, or giving robust consent. If I understood it correctly, so this is the idea that you must not only consent to sexual activity in general, but also the form of that activity, and have a clear picture of what the activity you consented to actually involves. And to my mind, it provokes an important question across legal fields where consent assumes relevance. One of them, the field in which you practice, is medicine and medical negligence. And straight away, I was thinking, can we retain conceptual unity of the concept of consent And can we have that account of robust consent across fields or operating across legal fields? Because when you think about medical negligence and when you think about the case of Montgomery and how it has been refined in most recent decision by the Supreme Court in McCulloch, it seems to be the case that there is actually very little space for robust consent in medical law, because it will always be curtailed by therapeutic privilege, by the ability of the doctors to still choose which treatment is appropriate, even if you are if you have right to disclosure of risks inherent in the procedure. It will be still down to doctors to pick which treatment to go forward with. So that when I was thinking about this concept of kind of robust consent, is it, so to say, transferable to other fields of law? And if not, then does it undermine, so to say, unity? Does it undermine analytical unity and conceptual unity of the concept of consent? Or is it perhaps fine to have different accounts of consent for different fields of law, which will operate within that narrow realm, if it makes sense? That's a very long question that I asked. Yeah. But I was fascinated with this idea of a very rich conception of consent that the idea of robust consent involves.
Yeah, so it's a great question. And so I'll say a couple things. First, the notion of robust consent that I introduced in the paper is from a moral perspective, a scalar concept. Consent is more or less robust, right? So, so if we're talking about consent to sex, which I won't go into the whole back argument of this, but Jonathan Herring and I have argued that sexual penetration calls for justification from a moral perspective, which is just to say, like, it's not like just patting somebody on the back or shaking somebody's head. If we're talking about like penile vaginal or penile anal penetration, like you're entering somebody's body, there's risks of, tearing or harm, or, physical risks, psychological risks. And there's also this really messed up social meaning that attaches to the act, which, naughty word F, and, banging, slaying, effing, these like very violent, subordinating kinds of words connect to that act. And it's like not a mistake, right? It's not the only social meaning of the act, but it's there and it's part of it. And so if you take all of this together, we think like there's a case to say that justification is needed from a moral perspective. We're not saying it's needed from a criminal law perspective, or that it should be needed from a criminal law perspective. So with that in mind, then I was thinking about like what kind of justificatory work can consent do from a moral perspective? And I thought, well, the answer sort of depends on how robust the consent is, right? So you need to have to fully robust consent. There's sort of three and a fourth. Let's start with the three features of the consent itself, and then there's uptake. So I'll get to uptake in a second. The three features of the consent itself are whether the person has full capacity, right? Their mental abilities, their reasoning abilities, they're not intoxicated, they're not mentally debilitated in any way. So fully robust. So like, I don't know that anybody's like fully rational and fully, like, we may never be at that sort of apex of that rationality. There's also the requirement of knowledge. So capacity, knowledge, and voluntariness are the three things I'm going to talk about here. Capacity, I just explained. Knowledge is having a clear awareness of all the facts that are relevant to your consent, right? So some things you can't even know, right? Like some of it may be you're very, very sure that this is going to be a good time, but then it turns out it wasn't so good, right? So like if I'd known that it was going to be bad sex, I wouldn't have consented to it, right? So like there's just, we can't know everything, right? And there's all sorts of things that we just don't know when we consent to anything. Here we're talking about sex because that's what I write about a lot, like I said. But, you know, we may never have perfect knowledge. Now, at some point, our knowledge is going to be so deficient that it degrades the consent to the point where it does very little justificatory work, just like with capacity. If our capacity is so degraded that we're not able to reason properly, then our consent is going to be very low on the scale and it won't do a lot of justificatory work. And then there's voluntariness, the sort of idea of making a free choice, having this be a genuine exercise of your autonomy, sort of, and a very rich notion of autonomy would suggest that, like, maybe nothing we do is reflecting our full autonomy in that way and is fully voluntary, particularly in a world where structural inequalities shape our choices. And I think that's particularly salient in the area of sex. So, you know, there's lots of ways in which the choices that we make are not fully voluntary. So robust consent is sort of this ideal, the full capacity, full knowledge, full voluntariness. And the fourth thing that I kept off for a second is full uptake by the person to whom one is consenting, right? So on my view, the sort of moral magic of consent, the way it works as a matter of morality from a moral normative perspective, is that it when it works, and to the extent that it works, again, it's a scalar concept, it grants the person to whom one is consenting an exclusionary permission. And this is one of many, many, many things I borrowed from Joseph Raz. So he explains the normative force of consent in this way. And I think he's right from a moral perspective. Consent works very differently in law. But if we're just talking about sort of I keep saying a moral perspective without explaining what it is. Roughly, it's sort of like our moral ledger, the kind of moral tapestry of our lives, separate and apart from whether we could be held legally responsible in some way, and even separate and apart from the justifiable holding to account that we do in society, right? So it's not even like a second personal moral perspective. It's like, I'm thinking of morality as very much a sort of, you know, it's you and your moral ledger, like you've got a moral tapestry of your life, and that's what I'm talking about when I talk about the moral perspective. So from this perspective, then, if you had fully robust consent that was with full capacity, full knowledge, full voluntariness, and the person to whom you consented fully took up the exclusionary permission that was on offer when you consent to them. That means that they are aware of it, they care about it, and they actually exercise on their rational horizons the normative force of that exclusionary permission, such that they're able to exclude some reasons they would otherwise have not to engage in this act, here, sex. But this story plays out across everything. This isn't like a particular sex conversation. It's just, again, that's the way that I tend to write about it. So I think consent works this way across a lot of different fields. And that's, I think, how it works in morality. And if it turns out your consent is degraded or there's less than ideal full uptake, then that just means that, like, the moral ledger of the person who went ahead and did it based on your consent, or maybe irrespective of your consent if there's no uptake, their moral ledger looks a little different. The moral tapestry of their lives is blighted in some way because something's gone wrong with this consent here, right? And I just think that's sort of always the case, right? I don't think there's nobody's got a perfect moral ledger. You know, morality is demanding. I'm not a huge fan of these theories that say, oh, morality can't be too demanding. It's like, morality is just as demanding as it is, you know, like, so yeah, so that's the story from the moral point of view. From a legal point of view, which I take your question to be more focused on, consent works very differently. And, you know, in criminal law, let's just say with respect to like battery versus sex, sometimes consent, like in a battery case, works as a justification. So it still plays that kind of justificatory role that I was talking about before. It works very differently, but it's still, in principle, on that side of the equation. it justifies what would otherwise be a prima facie wrong, which is the phrase we would use in law to describe what's going on there. And when it comes to things like battery, if it's fully consensual, oftentimes, like in a boxing match, it can serve as a full justification. Not all the time, like there's other places where you're not allowed to just go and punch each other, but oftentimes and in certain settings, consent can provide that full justification. Other times, consent has a very different function in criminal law, like with sex, where as a descriptive matter, it's the non-consent that matters, right? Like there's nothing wrong with having sex as a legal matter, nor do I think there should be, right? It's the non-consent that makes it a prima facie wrong as far as the law is concerned. And I think that's right. Like, because when we think about what the law should be doing about things, we're no longer just trying to like write WRITE, to write from morality and drop it into law, to like decide what the criminal law should do based on the morality of the underlying act. Instead, we're asking a very different question. We're shifting our normative perspective, and we're saying, oh, okay, when we use the law, especially the criminal law, we now have a whole different agent in view, and that's the state. And so we need to ask, like, what is the state doing here? And does their conduct call for justification? When it comes to the criminal law, the state's doing a lot of things that call for justification. They're prohibiting things, they're threatening punishment, all sorts of things in the criminal law call for justification. And so the question then becomes, or like, under what circumstances might the state be justified in doing what it does? And that means that it's just operating with a whole different set of questions and conceptual tools. And I don't think it's a horrible thing that we use the same word, consent, across both normative perspectives, but the point of my paper was like, we got to keep these separate. Like, there's no reason to think that these are actually in fundamental ways asking similar questions. So that's one big difference, a moral perspective versus a legal perspective. When it comes to consent, very different things are going on. And then to finally answer your question, I hope, which is, in the law, there's a lot of different areas of law, right? There's criminal law battery, criminal law sex, there's tort law, there's malpractice, and you were asking about medical malpractice and the role of informed consent there. And I think, again, the absolutely going to differ depending on the area of law you're talking about. And I think the reason why it differs isn't because it's something sort of essential to consent. It's because the question we're asking in medical malpractice law, when we're asking about informed consent, is a question about what the state can do, at very least in terms of like setting up a system of tort law to allow for someone who has been believes they've been victimized by a tort to pursue damages against the entity or person that has harmed them and wronged them. I think torts are wrongs as well. And so you're just asking something different. Like, when we do that and provide the system and structure these rules for people to come and seek tort relief, does that call for justification? Yeah. I mean, you're setting up a very powerful system in which some people's lives can be seriously messed up if they're subject to a major tort suit and don't have insurance. That's a whole other story. But yes, I think allowing for that kind of cause of action calls for justification itself. And so then you just have to run the argument again, like, okay, what might justify that? Well, we would look at things like the rights and autonomy of the person who is injured, and under what circumstances should, for the sake of providing tort remedy, under which circumstances should we say that consent is good enough? And that's a very different question than whether consent is good enough to justify a battery, or whether consent is good enough such that it stops sex from becoming rape. And so we just have to ask that question individually in each particular area. And and one last thing, importantly, whenever we're asking these questions from a legal perspective, we're dealing with a concept of consent that is no longer fully scalar, right? This is not just a matter of degree. This is a matter of thresholds, right? You either consent or you don't. And okay, the law's not, crystal clear, fine, but like it aspires to be very clear, right? The rule of law, principle of legality, we should aspire that our law will be as clear as we reasonably can make it, and that these thresholds should exist so that we don't like run around telling people, well, you kind of battered that person. Like, what is that? We could say that from a political perspective, like a socio-political perspective that exists in between the moral and the legal. Sure, we could be like, well, you kind of battered him, or that what that guy did was kind of rapey, like we could say those things from a certain normative perspective, but we certainly shouldn't be saying them from a legal perspective, right? We have to have these thresholds to bring more clarity. And the same is true in tort, right? Someone's either found liable or they're not, right? That's it. I
think this is a very refreshing answer, because many scholars who work in theoretical field would insist on uniformity of certain concepts, that they actually do offer clear boundaries within which to work. So I think it's very refreshing that your work does recognize that plurality and richness of the of concepts, whilst being attuned to contexts within which those concepts operate.
But then,
thank you.
I think, Michelle, even in your paper, you say morality is messy, but arguably so is law and so is politics. I think it's just a matter of degree to the messiness of each field, and so it's fascinating to read through your paper when you're thinking, even in your paper about criminal law, the second paper, you have a very clear idea of how those three fields interact, and how you're kind of like a chaos tamer, almost, I would say, because to start introducing, tests in morality, and effectively what you're doing with those criteria, it is, even if you don't specify them necessarily as such, it's like, let me tame this and let me actually shave off some of the fuzzy edges so we can have almost like a common sense. This is clearly what we're getting at when we are talking about, like, I don't want to use the word ideal consent, but like the concept of consent, right? So let's like shut down some of those discussions around the edges we all know this is not what we're trying to do here. Like, this is not what the purpose of this as a concept is. And when thinking through that, I also, and I'm conscious of time, we're also looking at your other paper where you talk a lot about public wrongs. And I wonder if you could do a similar dissection of why should we care about public wrongs? Like, because that goes directly to the heart of not just, morality, politics, or law, but it also goes to the very heart of justifying law or criminal law in a way that you mentioned in the beginning of today's episode.
Okay, so why should we care about public wrongs? So my answer is sort of very much of a piece with the kind of answer that Antony Duff would offer. So I want to just sort of start there as a touchstone, because I think so much of what Antony Duff has had to say about criminal law and the communicative function of criminal law and public wrongs is insightful and helpful and correct. Where he and I differ, and let me tell you what the basic way he would unpack this idea is that public wrongs are things that the polity must care about, must respond to, and must call wrongdoers to account for, in order to be true to itself, right? Like, these are the defining values of our polity. This wrong has acted against those, infringed, violated those, and we need to call that person to account. And so it sort of weds together the idea of public wrongs with the communicative theory of punishment. And it's about sort of the conversation we are having with ourselves as a polity, as a political community, and the way that we cultivate who we are. Well, this is where maybe I'm coming in more. I think a lot of Anthony Duff's work on this has been about remaining true to our defining values. And I'm like, some of our defining values suck. I mean, excuse my language, or like our political communities are deeply unjust in all sorts of ways. We're just riddled head to toe with structural inequalities. And I don't think we should be in the business of trying to like preserve everything that we are, right? We ought to be in the business of trying to interrogate and change. And so one of the values that I emphasize in my account of public wrongs is the ability of responding to public wrongs, either through the criminal law or in lots of other ways, through like alternate sites of public accountability, non-criminal ways, even non-legal ways, where we call one another to account. We not only are able there in the calling to account to denounce the alleged wrong and have a sort of public conversation about where are the borders, like where are we justified in holding one another to account, and what kinds of wrongs are these? I think that the way that we label wrongs is fascinating, and it has a lot to do with the way that we not only understand ourselves but grow morally as a community. So this sort of process of denunciation and dialogue around the alleged wrongs. And then importantly, and this is one of the major themes of my first book on prosecuting domestic violence, is the ability of our responses to realize what I call constitutive value, which is the value of a political community, a state or political community, cultivating valuable character traits. And through habituated actions that denounce wrongdoing and make salient its wrong-making features, we can act against those features. We can be like, no. So like the basic thesis of the book is domestic violence prosecutors should be feminists. And the whole book is just unpacking that claim. And the basic idea is that one thing they should aim to do is to not just take domestic violence more seriously so that they never dismiss any domestic violence case, no matter what it is. And if they did that, they'd be going to the wall on cases of, cousins getting into a fight with one another at a barbecue, or like college roommates getting into it, over who didn't clean the toilet or something, right? Like there's a lot of things that, as far as the law is concerned, count as domestic violence, but they're not really what we need to be focusing on if we want to reconstitute the character of our community to be less patriarchal. And that's what I understand to be feminist is. It's like the opposite character trait from being patriarchal. What we should do is disaggregate domestic violence into at least two different categories. Domestic violence in its weak sense, which is those cases where it's like, yeah, it's domestic violence, but it's not the kind that has a tendency to sustain and perpetuate patriarchy, right? Like it's not grounded in patriarchal norms, and it doesn't have a tendency to perpetuate patriarchy. That kind of domestic violence is the one that we really ought to be concerned about. And when we disaggregate them and really isolate that second category, we can thereby make salient those wrong-making features that are connected to patriarchy, and we can denounce them. And if we do that habitually, we thereby transform our character, right? We cultivate a better character with respect to, moving from being more patriarchal to being more feminist. We are, to steal something from another professor of mine who has been very influential in my thought, Catherine McKinnon, we're moving like toward a feminist state or toward a feminist political community. So did I answer your question? I feel like I just
you absolutely did. You absolutely did. Thank you.
Okay. All right.
I really wish we had more time to speak because this paper is absolutely fascinating, and some of the questions, if we had more time, I would ask, would be the question on secondary duties, which are connected, which are at heart of this article, and I'm very curious how do we actually encourage this type of secondary duties to be carried out, if they impose a kind of positive obligation.
Yeah.
On,
So I guess what you're saying, Emilia, is we're going to need a part 2 because, you know,
Yeah.
we are 1 minute away, and I don't think it's fair to give Michelle 1 minute to answer.
No, I didn't ask. I said I just wanted to leave it as one of the questions that kind of this paper provokes, and I wish we had more time to discuss on kind of the positive character of those secondary duties, if that's the character. But it was absolutely.
Can I, rather than try to answer the question myself, tell people they should read Linda Radzik's. Oh, I'm so embarrassed. I'm horrible with names. I know it's Linda Radzik, but I can't remember the name of the book. It's based on her lectures. I can't remember what lecture series it was.
We're going to include a link. Don't worry. I'll find it. We'll make sure it's included in the description. But
it's terrific. And she's exploring like non-legal, non-criminal ways to respond to wrongdoing. And I fully endorse that project, right? I'm a criminal lawyer and that's what I think about, but I definitely don't think we should be using that as the main tool by which we as a society respond to wrongdoing.
Thank you so much, Michelle. Thank you for recommendation and for your incredibly insightful responses and the papers, which were fascinating for both of us to read. It was great pleasure to have you on our episode of Just Theory podcast. Thank you.
Thank you so much, Michelle. This is such a privilege.
Thank you so much for having me. It was a delight and a great honor. Thank you.